Good afternoon.
Good afternoon.
Hello, Lee. How are you?
Very well indeed. Is this the first round you're judging, or have you done some earlier today?
I have done one earlier. To be honest, 1.5.
How was the technology holding up for you in the rounds?
To be honest, it's fine. It's fine. For the first session, there was some problem in the beginning, but then they sorted out. And the second session, which I was running with my colleague, it was good, you know. Things was very nice.
Oh, good. Good. And how were the standards? We probably shouldn't speak so openly. All I was just going to say, from the skeletons I've read for this round, it looks like both teams are good.
I hope so. But I think this is your first session today, right?
Second.
Second. Good.
Yeah.
So that's you have an experience better than me.
Yeah.
Okay, so I think Lee,
yeah.
I will give you to lead this. It's your call.
You want me to lead it? Did you say?
Yeah, it's fine. You can just start it. I mean.
Sorry.
Yeah.
Okay. Can we just check then if everyone can hear us? And
I'm seeing that some are missing, you know. So I don't know if we can get them time a little bit, 5 minutes more. Do you think it's fine by you?
Yeah, it's fine. As I say, I can certainly see 4 students in the room, but I wonder if perhaps we could ask one of Appellant speakers from the University of Exeter just to confirm that you're both here and can hear us.
Yeah. So I think Yara Jadallah, she is from University of Exeter, representing the Appellant team. Yara, can you hear us, Yara? I guess Yara, she's opened the, she just switched off the mic. Okay.
Yara, would you mind? I can see that James has switched his mic on. Can you hear us, James?
James and Yara, if anyone is hearing us, please let us know.
James, that's right. We can't hear you. I can see it. Sorry, I'm just referring to the message in the chat. Everyone, please do, by all means, log off and log back on. Just if it helps you guys, before you do that, we can see on the list of participants that Huda has her mic off and her camera off. Janatul, same, mic off and camera off. It looks like Yara and James have cameras on but mics on mute. So it might be that you just need to switch your microphones on and then we can hear you.
Can I try? Can you hear me?
We can hear you now, Janatul. So,
okay.
What's the correct pronunciation of your first name?
Janatul. Yeah.
Janatul. Say again.
So it's Janatul, but yeah.
Janatul.
Yeah.
Okay. And your surname? What's the correct pronunciation?
So it's Janatul Firdaus. I think that will be better to say.
Mm-hmm.
Yeah.
Okay. Fine. And just tell us, Janital, and are you the first or the second speaker?
So I'm the first speaker. I'm representing Middlesex University. I'll be the senior respondent, and the junior respondent will be Huda Nasim.
So I think we are waiting, Lee, we are waiting for the senior appellant to appear. So I think it's still Firdaus will be in the second one.
Yeah, to wait for a little bit.
Yeah, so Huda and Yara, can you hear us, Huda and Yara?
Huda is from Middlesex. She's representing junior.
Huda can, sorry, it's Huda James, isn't it? Huda?
I'm sorry?
We just wanted to make sure that you can hear us and also that James can as well.
Yes, so you're audible.
Okay, and who on your side, Huda, who's speaking first and who's speaking second?
So I represent Middlesex and Janathul is the senior respondent and I am the junior respondent.
Of course, sorry, I've just written that down. I'm just forgive me, Huda. I just want to check with the other two, James and Yara. If you need to log off and log back in, that's absolutely fine. We can see Yara now. Can you hear us, Yara? Put your mic on.
Yes, I can hear you. Can you hear me?
Yes, I can.
Can you hear me?
Yeah, we can hear you perfectly.
Perfect.
Okay, and you're the first speaker or second speaker?
I am the first speaker.
So you're the senior appellant?
Yes.
Okay. And can I just check before we go on that James both can hear us and that we can hear him? Would you mind just saying something, James, so we can know that we can hear you?
Okay, it doesn't appear that we the mic is working, so we're just gonna.
But we are in the same room.
We are in the...
Oh my God! Sorry. Oh, fine. No. Okay, I hadn't realised that because certainly me and my colleague are not in the same room at all. I think we're not even in the same side of the planet. But that's fine. So you've got a work. You're in the same room with a working. Absolutely perfect. That's brilliant. Thank you.
Right. So
all right.
We'll share.
No, of course. No. I didn't realise you guys were in the same room. That's perfect. No problem at all. We can just focus. All right. Well, look. Welcome everybody to the preliminary round of, I think, the inaugural DIFC Digital Economic Court mooting competition. We're conscious that we've probably got quite a bit to get through. So just help us before you start, Yara. I'm going to call you by your first name, although obviously in court, judges tend not to do that. I hope that's all right. Just tell us, have you decided how long each of you wants to speak for, how you're going to divide your time up?
So we aim to divide our time equally. And also roughly around 10 minutes per speaking so that we can leave time for rebuttal.
Okay, so about 10 minutes.
Could we just, before we begin, could we ask how you would like to be addressed? Lordship or Your Honor, or what's your preference?
I'm going to let Ahmed answer that because I have no delusions of grandeur at all. But you know, he may want to be His Royal Highness, His Majesty, His Excellency. I don't know. How would you like to be addressed, Ahmed?
Lee, we can say Mr. Lee and Mr. Ahmed is fine by us.
Okay. Again, I mean, looking at, obviously in a real court, there would be proper titles and things, but yeah. I'll tell you what, just to make it easier for you, I think most jurisdictions, I believe at this level, would probably say Your Honor, I think. So we can do that if that makes it easier for you. Because you would never call a judge just Mr. X by their surname, but...
No, Your Honor, Mr. Lee, Your Honor, Mr. Ahmed, like this. Okay.
Fine. All right, Yara will please do open the case for the appellant.
So, good afternoon. My name is Yara Jadallah, and I am here before you with my learned junior, James Braham. We are appearing for the appellant, Mr. Laith Payne. So we hope that Your Honor today finds that the disputed trade was legitimate and should not have been void. We appeal the decision taken in the Court of First Instance on two grounds. The first being that the Court of First Instance erred in concluding that because Clevity operated distributed ledger with a node in the DIFC, that the DIFC court had jurisdiction over the claim by Ms. Rani against Mr. Payne under Article 5A1B of the Judicial Authority Law. Our second ground is that the Court of First Instance erred in concluding that Article 36(1)A of the DIFC contract law was sufficiently satisfied by Ms. Rani, showing that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was the result of an error. I will be challenging the court's jurisdiction, while my learned junior James tackles the issue surrounding the relevant mistake. So to challenge the Court of First Instance's jurisdiction, I will be reviewing the facts of the case and questioning the applicability of the authority by applying the facts and the relevant legal material. The judge in the Court of First Instance erred in concluding that because Clevity operated a distributed ledger with a node in the DIFC, that the DIFC court had jurisdiction over the claim. The judgment relied on a decision made in 2011 in the case of Al-Khurafi and Bank Saracen, and particularly paragraph 60 to 65. So the paragraphs can be found on page 10 of the appellant's bundle. So in this case, it was held at paragraph 61 that each of the component contracts was a part of the overall investment transaction, and each such component was at least partly, if not wholly, concluded in the DIFC. However, let us consider the facts of the case before the court today. We have a valid contract with offer, acceptance, and consideration in the form of a transaction. Nevertheless, there is uncertainty around where this transaction took place. This is quite unlike the facts that were found in the case of Al-Khurafi and Bank Saracen. So the transaction in Al-Khurafi and Bank Saracen had interacted with the DIFC and was at least partially conducted in the DIFC. Nevertheless, the case before us today, the transaction was done on the cryptocurrency trading platform Clevity. Clevity is hosted on a distributed ledger across hundreds of digital nodes in many countries and locations, including the DIFC. Now, due to the nature of this decentralized system, we are unable to track which nodes exactly interacted with the transaction in question. There is no evidence that points to the interaction of the transaction with the node in the DIFC, and with no evidence, we cannot know for certain or assume that the transaction took place, that the interaction, took place in the first place. And if we have no evidence that the DIFC is involved, how can the DIFC court have jurisdiction to rule on such a matter? So now that we have examined the facts of the case before us, let's apply the relevant legal material. If I could please invite Your Honor to turn to page 12 of the appellant's bundle, where you will find law number 12 of 2004 in respect of the Judicial Authority of Dubai International Financial Center.
Yeah, we have that. Thank you. Which is the bit
So
you'd
in
like
front
us to
of
look
you,
at.
So in front of you, you have Article 5A1B, which grants the Court of First Instance exclusive jurisdiction to hear and determine matters relating to civil or commercial claims and actions arising out of or relating to a contract or promise contract, whether partially or wholly concluded, finalized, or performed within DIFC, or will be performed, or is supposed to be performed within DIFC, of course, pursuant to express and implied terms stipulated in the contract. So while a transaction fulfills the elements of a commercial contract, it does not in any degree relate to the DIFC in terms of the parties involved. There is also no evidence of it being partially or wholly concluded, finalized, or performed within the DIFC, or that it will be performed or is supposed to be performed within the DIFC. Again, while this section was applicable in the case between Al-Khurafi and Bank Sarasin, the context of our case is significantly different, making this judgment an inappropriate one to rely upon. And why is that? It's purely because of the location. So the fine but crucial details are sufficiently different in the two cases, to the point where the case before you cannot rely on Al-Khurafi and Bank Sarasin's applicability to the law, purely due to that crucial detail of the interaction with the DIFC. So in Al-Khurafi, that was satisfied because there was the transaction that was related to the DIFC. And that did satisfy Article 5. However, that is not applicable here today. So in light of the uncertainty around where this transaction took place, we cannot simply assume that it did, partially or wholly, was performed in the DIFC. Without the certainty of this crucial fact, we cannot grant the DIFC's Court of First Instance exclusive jurisdiction on the matter, where the law does not even grant them one. Nevertheless, Section B1A of the same law grants you, Your Honor, exclusive jurisdiction to overrule a decision that should not have been taken in the first place. On the basis of the foregoing, we ask Your Honor to hold that the Court of First Instance erred in concluding that because Clevity operated a distributed ledger with a node in the DIFC, that the DIFC court had jurisdiction over the claim by Ms. Rani against Mr. Payne under Article 5A 1B of the Judicial Law.
So,
if I need
Yara,
further assistance,
Yara,
yeah.
Hold on, please. Here, how you can define or you avoid supposed to be performed in the DIFC, supposed to be performed? How you can avoid this? How you can determine this? How you can say this is not relevant? Supposed to be reformed.
So both parties are from regions that are outside the DIFC. So that's to start off. So this is our parties. Now, in terms of transactions, it was done on the platform Clevity, which is decentralized, and it has different nodes in multiple locations across the world. So even though there is one in the DIFC, you cannot be certain that this transaction that we are talking about that took place interacted or was supposed to be done in the DIFC one. So this lack of uncertainty.
Okay, yeah, do you think so? Since you are saying there is hundreds of nodes around the world, and it could be any of these nodes, which is not essentially or should be in the DIFC. But again, I'm saying, suppose that it has happened during the DIFC node.
There's no
evidence. Assume that,
we cannot.
But you cannot avoid it. But you cannot avoid it in the meantime.
Can I ask, Yara? We take and understand your point that there's no evidence that the particular node in question was switched on or interacting at all. Would your position change if there was evidence that it did, or are you saying that it doesn't matter anyway because it's just one node?
So first of all, obviously my co-counsel will discuss the issue of relevant mistake, which would further support our argument. But in terms of jurisdiction, the issue would be uncertainty. Now, if Clevity were to give a report or anything to prove that it was, even though the chances of them doing that are highly likely due to the nature of the decentralized system, then maybe it would change, but we would still argue relevant mistake, as my co-counsel will do.
So
but
just,
the issue
just
of jurisdiction
to be clear,
is
Yara.
Yeah, sorry.
Yeah, I'm just asking about jurisdiction. We understand that James is going to deal with mistake. And what we want to understand from your argument is, are you saying the only difficulty, don't have any evidence whether this node was operating or not? Or are you going further than that and saying, even if you could prove this node was operating, that's just one of thousands all over the world. And if all it takes is one node, because if you think about it, if it just takes one node, suppose there's one node in India. Shouldn't India have jurisdiction?
So-
If there's one node in London, should London have jurisdiction? So what I want to understand from you is your argument just that there's an evidential problem here? We don't know whether this node was interacting, or are you saying it doesn't matter whether it was interacting or because one node wouldn't be sufficient anyway? Do you understand my question?
Yeah, yes, thank you for the clarification. Okay. So if we were to assume that all of them had the same legal constrictions on jurisdiction, if we were to assume that, and let's say the one of the parties was from London and the node in London was interacted with, then I would say that London does have jurisdiction. And in this case, if we have sufficient evidence that the node that's present in the DIFC had interacted with the transaction, then yes, potentially also based on other legal
so what, as I understand it, what you're saying is in relation to our jurisdiction here in the DIFC, what you seem to be arguing to us is if the other side go away and get an expert report and prove that there was one node in the DIFC operating and interacting with this transaction, you would then have no further challenge to our jurisdiction?
Correct.
Is that right? You're saying if they go and get an expert who says, yeah. All right. Yeah. If that, in that case, question for you, suppose this expert said, and let's assume this expert was a very annoying person and they went way beyond what you asked, and you said, and they said to you, do you know what, as well as there being a node in the DIFC that was operational and interacted, but there was also one in London, one in India, one in Singapore, one in France. Yeah. And he's got evidence of all these other 4 jurisdictions. What would you say then about whether we should take the case or not? Who has jurisdiction then? Because we know it's a network around the world, don't we?
It is, and the law tells us, the DIFC authority jurisdiction law, Article 5, tells us that only one. It only requires one. So even if it was only partially interacted with the node in the DIFC would have jurisdiction.
Where does the DIFC law tell us that one node is sufficient? Does it tell us that?
One, since they don't provide any further justification on partially, one node is, partially, and it is.
Is it? Partially what though? I have to think about that.
Article 5A1B. It says, sorry, give me a second. Article 5A1B on page 12. Civil or commercial claims and actions arising out of or relating to a contract or promise contract, whether partially or wholly concluded.
I understand the wholly and partially bit, but what we're asking you is, when you say one node is sufficient, are you saying that this is the concluding the contract, the finalizing the contract, or the performing the contract? Which one is? Okay, and just one node's doing that, is it?
Because either would be considered as an interaction. Either one would be, okay. So either one of the elements would be sufficient enough for the DIFC to take the case on. However, we do stand that there is no evidence of that for the.
Okay, and can you help us with on 5A subsection B? What about these words at the end of it, where it says pursuant to express or implied terms stipulated in the contract? How do we apply that here?
So a contract is the contract.
All I was going to ask you is it a term of the contract that this particular node in the DIFC has to be involved?
No, not necessarily.
So where does that take us?
Well, each contract would have. Each contract has express and implied terms, and in this case, since it's done by algorithmic trading, I would assume it's implied. And the interaction with the DIFC, I mean, if it wasn't within the DIFC or had not interacted with the DIFC, there is no reason for the DIFC to hear the case because it's completely irrelevant to them.
Okay. All right. Well, that was the questions that I had for you. I'm conscious I don't want to take away any more of your time. Did Ahmed, I think, do you have a question?
Yes. Yeah. So if we are saying that Clifty's platform is operating partially from DIFC, so I think there is interaction between DIFC and the platform hosting the programs. So how you can avoid this part?
So not necessarily, because even though Clevity has a node in the DIFC, so it's essentially kind of like this big cloud with multiple servers all around. So just because one of the servers, which is the node, is in the DIFC does not mean that it interacted with the transaction. And we do not know whether it interacted or not. We do not have absolute certainty or even any certainty that it interacted. It might have, it could have, it might have had the potential of, but that does not give us evidence or to say that it did interact.
I'm not saying about the node itself. I'm saying as a Clevity organization, an institution, licensed, or they be operating from the DIFC. So according to the DIFC laws, it said if there is any relevant to the DIFC with any contract or transaction, so there is a relevant point that Clevity is hosted by the DIFC itself, regardless of the nodes.
So
as a platform.
Clevity is an international trading platform. So it's kind of like blockchain. It operates everywhere. But it operates like a cloud. It essentially operates like a cloud, and it has servers, nodes in multiple locations, including the DIFC, but not every transaction goes through all of the nodes.
So that means you will take us to another area that no court has jurisdiction on these transactions, according to what you are saying.
No, you do have jurisdiction if we have proof that it interacted with the node in the DIFC. Then the court of first instance would have jurisdiction.
There is interaction. They are the platform. They have a link with the DIFC. So there is a proof that they have a link. So there is a court in this world has a jurisdiction. So it's a dispute and debate point, which I will not focus more than this part. So you can continue.
Oh, so my co-counsel James would like to proceed to discuss relevant mistake.
Hello. You're seeing me from several angles.
Sorry, James. We better just stick to the format.
Right.
So
I was about to say.
you're going to get a chance to speak in a moment. Don't worry.
Yes.
I just wanted to check, Yara. We're conscious that myself and Ahmed have asked you quite a lot of questions. Had you reached the end of your submissions, or was there anything further you wanted in asking you lots of questions? It's only because we like your argument that we're asking you the questions. I promise you. Not a criticism.
Thank you. So to conclude, I would like to briefly conclude that Clevity is a decentralized platform of trading, and it has multiple nodes across the world, only one of which, or partially, is in the DIFC. So transactions could interact with multiple nodes. However, we do not have certainty that the transaction in question interacted with the one in the DIFC. And on that basis, we are saying that the court of first instance did not have jurisdiction to rule on the matter. These are my submissions.
Okay. Thank you very much, Yara. And if we could now invite the first speaker for the respondent, the senior respondent, who I think is going to be, forgive me, I've not made a note of it.
It's fine. Janatul Firdaus.
Isn't it?
Yeah.
Yep. Thank you very much, Janital Fidus.
Okay, so I'll
Please do
start.
start.
All right, okay. May it please your honors, my name is Janatal Firdaus and I appear as the senior counsel on behalf of the respondent, Ms. Rani. I'll be speaking about the first ground, which has been submitted by the respondents. I also have with me my learned co-counsel, Ms. Huda Naseem, who will be speaking on the second ground on behalf of the respondent. Your honor, as you're aware, the appellant has argued that the dismissal of the submissions by the Digital Economy Court judge in the Court of First Instance has erred in concluding that the DIFC has jurisdiction over the disputed trade under Article 5, Section A, Subsection 1, Subsection B, and Article 37, Section A, Section 1, Subsection A of the DFC contract law, that the court did not need to examine the state of mind of the programmer when designing the program. However, the respondent asks the court to uphold the decision made in the Court of Appeal because of the following grounds. Firstly, DIFC's jurisdiction is applicable in the disputed trade which we are dealing with. Secondly, the glitch in the program was an unforeseeable technical error and was a unilateral mistake. Henceforth, the distributed trade should be rendered void. For the first ground, I have 3 submissions to make. If it pleases your honor, I'll begin with my first submission. So the first submission is how the disputed trade is validated if claims are brought to DIFC and can help with debt recovery proceedings. So Clevity being a distributed ledger having one node on a server based within the DIFC, it authorizes the body to award exclusive jurisdiction to hear and determine civil and commercial cases. In addition to this, Clevity is a party to DIFC, and they can seek judicial authority at DIFC under DIFC Article 5, Section A, Subsection 1. Alongside, the Digital Economy Court is a specialist division of the DIFC courts. According to Part 58, Section 3 of the Digital Economy Court. Alongside, according to Article 5, Section A, Subsection C, the disputed trade is related to DIFC activities. The parties agree when in writing that DIFC decision may prevail once it is proven that DIFC has jurisdiction for deciding the present case pursuant to Article 5, Section A, Subsection 2. Likewise, according to the above mentioned legislations, it can be concluded case of a recent DIFC Court of Appeal decision in I hope I'm saying it correctly, Goyle and others versus Credit Suisse, which is Switzerland Limited. This was a case about regarding a guarantee agreement made by 4 guarantors, I hope I'm saying that right, who are actually non-DIFC entities. But in this case, it was confirmed that DIFC is indeed a court of Dubai and that non-DIFC entities who intend to opt in to the jurisdiction of the DIFC courts can do so. To further give further evidence, to further justify my claim, I will quote Justice Martin from this case, where he stated that the fact that Credit Suisse was a DIFC establishment at the time, each guarantee was signed is a factor which points very strongly towards the conclusion that it was the mutual intention of the parties that the DIFC courts were to be included within the meaning of the expression courts of Dubai. So because Ms. Rani and Mr. Payne, they have seeked help from DIFC for their claims, and more specifically, they have a node at DIFC. Clevity has a node at DIFC. This means that they do have jurisdiction and they can bring their claim here. I will now move on to my second submission, which is that the DEC supports claims for distributed ledger technology. So according to Part 58 of the Digital Economy Court under Part 58, Section 5, it is stated that a digital economy claim can be considered if they fulfill the requirements stated in Part 58, Section 7, which states that a claim relating to the digital economy can be distributed ledger technology and blockchains. This includes blockchain technology and also applications related to blockchain technology. So even though Mr. Payne resides in Oman and Ms. Rani resides in Dubai, since there is a node in DIFC and the dispute involves blockchain technology, DIFC has jurisdiction to award a decision on this case. Furthermore, Central Bank of Oman stated strictly recently that there is no legislation for cryptocurrency transaction as of yet, and that they are studying and looking into it to create legislation. And in order for the best options for this disputed trade, DIFC is the best option either ways for both parties. More importantly, DFSA has collaborated with the Central Bank of Oman recently as well to overlook the authorization of such disputes. And now I will proceed to my third and final submission, which is the claim and how it is valid in terms of rules involving financing. So when Yapple and Beta made the unfortunate transaction, automated transaction, this caused Ms. Rani to have a loss and create a claim involving $250,000, which is a lot of money. And the main reason why our client chose to have algorithmic trading in the first place was to make things easier for her, for traders like Ms. Rani. However, in this case, it was different. The outcome turned out to be different for her. And moreover, because the integrity of the jurisdiction has been questioned, it puts Ms. Rani in a situation where she is in debt, and this was never, she did not expect to be in such position. So nevertheless, it should be pointed out that unlike the claims by my learned friend on the other side about how DIFC does not have jurisdiction, according to the DEC rulebook, such claims are valid within the jurisdiction involving amounts that does not exceed more than $500,000. As mentioned, the amount that Ms. Rani is in debt involves $250,000. Yes, so Your Honor, these were my submissions for ground one. My learned friend will later proceed with submissions for ground two. Thank you.
Thank you, Yara. Ahmed, do you have any questions for Yara? I'm so sorry, for Janatul Fardous, forgive me. Do you have any questions for her? Ahmed, do you have any questions?
Okay.
Oh, no, sorry, I'm not asking you. I'm asking my colleague, my brother judge. Do you have any questions? Can hear some. I'll ask you. So let me just say.
Sorry. Sorry, the mic was off. I'm sorry. No, for the time being, I don't have anything with Fardous. Thank you.
All right. Well, in that case, perhaps you can help me. You've given us 3 submissions. Your second submission refers us to Part 58, and you're basically telling us that we're very well equipped to judge this case because we're a digital economy court and we have the expertise, and most of that, I can assure you, is in my colleague and not me, but nonetheless, thank you very much. We agree with you. And you've told us as well on your third, so no one would disagree with, that in terms of the limit of the claim, you're well within our limit. And again, we have jurisdiction in that sense, and we agree with you. But it's your first submission I want to ask about. And it's this question we were taking up with the appellant as well. As we understand it, a node is just a device on the network, isn't it? It could be a computer, it could be a printer. It's a device connected to a network. That's what a node is. And the point, well, I suppose there are 2 points really. The first is, as was pointed out, whether this particular node in the DIFC was working, switched on, functioning, We don't know whether if it was functioning, if it interacted with this particular transaction at all. But then there's the bigger question, which is that we know that the Clevity network is global. They've got no particular ties to the DIFC. They have computers all over the place, servers everywhere. So what happens if somebody comes back to us and says, well, we can prove that the DIFC node was working and functioning and interacting, but we've also found one in Singapore and one in London and one in Switzerland. What do we do then? Can you help us with that?
I mean, I did want to use this sort of as a rebuttal, but I did find like a small point per my research that it is a theory that, you know, when you have a node and when you have such dispute regarding such transactions, that theoretically a transaction could be governed by the applicable law in any jurisdiction. So besides that, as I've mentioned, that it does not actually matter where the node is, whether it's in Singapore or elsewhere. The very fact that the claim was actually brought to DIFC in the first place alone should say that, you know, this is where the jurisdiction applies. Like it is applicable. I don't know if that answered your question.
I think so. So what you're saying is that even if there's lots of nodes all over the world, if it's been brought to us first, then it's okay for us to take exclusive jurisdiction. That's what what you're saying.
Yes, and if I just give me a moment. So because UAE is actually one of the first countries to actually introduce a court of this sort, the Digital Economy Court. So it is actually the best place, the best option for both parties to actually come by. I feel like I'm flattering a little bit. I don't know why, but that is.
What if I were to tell you that? What if I were to tell you that my brother judge, Mr. Ahmed, also sits in a digital court in Singapore, and he thinks the Singapore court is even better than the Dubai one? What would you say then?
I still think it would be applicable in DIFC because since one of the parties, Ms. Rani, is the one who actually reached out to DIFC in the first place. The moment she did that, and because there is a node that is available at DIFC, as I've mentioned in my second submission, that Part 58, Section 7, it deals with claims regarding distributed ledger, regarding blockchain technology. It also involves applications, whether it's third party or not, it doesn't matter. It's at the moment it is an application, blockchain application. They can bring the claim to DEC.
And what the appellant says, her counsel told us that we need to see some evidence of whether the node was actually working and interacting with this transaction. Do you think we need to see that evidence, or do you think that's not necessary?
So as per my research, I haven't seen anything regarding evidence. I have seen like directly in the DEC rulebook that as long as it's a blockchain related issue, you can bring it to DEC. And even regarding the amount involved as well, regarding transactions involving digital assets, you can bring it to DEC. And as I've also mentioned a case, let me just repeat it again. I feel like I'll make an error. It was Goel and others versus and others versus Credit Suisse Limited, where they were actually non-DIFC entities. They were actually based in Switzerland, but they were still able to manage. They still managed to have their case brought into UAE at DIFC, and they did manage to.
Yeah, but I just want to test the appellant's point on you, right? We're talking about one node in the DIFC, yeah?
Okay.
Now, suppose tomorrow we got a statement from a witness, and they said, we run the server bank where the node is in the DIFC. And unfortunately, when the cleaners came in the night before the transaction, they unplugged the server and they plugged in their vacuum cleaner. And so we didn't realize this for another 3 days. And so whilst this case, the DIFC node was switched off and not connected to the internet. You understand my question?
I did.
Yeah. So if we were to discover this, yeah. So that's what the appellant's saying. She's saying, well, the appellant counsel is saying, well, how do we even know that this node was operating? How do we know it was interacting with the transaction? And what I'm asking you is, do you think that that has any relevance to this, or do you think we don't need to worry about that?
I don't think there is anything to be worried about, because as I've mentioned, that it can, regardless of whether the node was there or not. I mean, if the node was there, it is a bonus point for us. But if it's not, the very fact that Ms. Rani, she came to DIFC with her claim involving digital transaction, involving digital asset and digital transaction and block, so that alone is one of the reasons why she can actually claim to be decided by the court, by the DIFC.
All right, well, that certainly answered my question. Ahmed, did you have any questions for the senior appellant, or do you want to move on to the
you can move, because you need the time. We are running so slow and time is limited.
Okay, well, in that case, we'll invite the senior appellant to give us her rebuttal.
So due to time constraints, I shall keep this brief. So first of all, I would like to remind the court that we are discussing the substance that we are discussing of the claim right now is jurisdiction. And I would also like to respond to a few of the things that the respondent has said. So the Swiss bank case, yes, they agreed to have the case heard by the DIFC. However, this is not the case in this transaction. There is no automatic agreement of opting in for our clients, opting into consenting to the DIFC hearing the claim. So that's one thing. And the other thing I wanted to say is that I would also like to remind the court that Clevity is not a DIFC establishment. It is international with a node in the DIFC. And the question of jurisdiction, the jurisdiction would lie upon whether that node was interacted with in this particular transaction. Since we have no evidence, we cannot say that they have jurisdiction. However, if there is evidence, credible evidence, then the circumstances would change. Thank you.
Well, thank you very much. And I think we now move to the junior appellant.
Good afternoon. My name is James Braham, and I have the pleasure of continuing. I apologize while I set up my I'll turn off the camera on the other device, and so I'll only be on one. Okay, right. So yes, good afternoon. My name is James Braham, and I have the pleasure of continuing the submissions for the appellant. As Your Honor is aware, my submissions surround the issue of relevant mistake. And in brief, it is our submission that the court at first instance erred in concluding that for the purpose of a claim to avoid a contract for relevant mistake, it was sufficient to satisfy Article 31A of the DIFC contract law that it be shown that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was a result of an error. And my submissions to Your Honors today will look at subsection A of the relevant law and then section 2. May I invite Your Honor to turn to Article 37 of the DIFC contract law at page 30 of the appellant's bond.
Yes.
Very well, thank you. The respondent relies on 37(1)(a), which reads, the other party made the same mistake or was also mistaken or caused the mistake. And what's important for the submissions before you today is or knew or ought to have known of the mistake. And it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. And it is our submission to Your Honor today that the correct test to be applied in the circumstances of deterministic algorithmic trading, as obtained in this case, is the test of when programming the algorithm, was the programmer doing so with actual or constructive knowledge of the fact that the relevant offer would only ever be accepted by a party operating under a mistake, and was the programmer acting to take advantage of such a mistake. And this test was established in the Singaporean Court of Appeal case of B2C2 at paragraph 103, and this can be found at page 65 of the Appellant bundle. And this Singaporean case is noteworthy because the factual matrix is almost identical to that of the case before Your Honor today, as it is mistake, the alleged mistake arose from a glitch on the cryptocurrency exchange in the event of both parties engaging in algorithmic trading. I'll proceed with the submissions to say that the court below applied the test of whether a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was in error. And we submit to Your Honor today that that is incorrect. The test applied by the court at first instance envisages a human trader completing the transaction. And as Your Honor is aware, there was and there is and there could not be a human trader executing this transaction as it was executed by the algorithm. And so to take again from B2C2 at paragraph 104 on page 66 of the Appellant's bundle, the test applied ignores the fact that the parties had committed to transact with each other in a certain way, which entails that they would not even know whether a contract would be formed, and if it were, on what terms that would be. And they chose in these circumstances not to bargain for the right to review, confirm, or invalidate any ensuing contract that may emerge out of the arrangements that they committed to. And so what this is saying to Your Honors today is that the parties agreed to engage in trading without themselves being involved. And so if we're to ask about a mistake, what ought to be known, or what one knew or ought to know, we can't bring the program before the court to ask the question, what do you know, or what ought. And if we want to know what the program ought to have known, we'd have to see what the program was instructed, how it was programmed, which means we have to go to the mind of the programmer at the time of creating the program. And so, and that is my first submission to Your Honor today. Secondly, neither the facts nor the law accommodate the court artificially imposing another last look. And so this is in reference to the notion of mistaken equity. Another last look to the proposed terms immediately prior to the algorithms concluding the contract, and for that matter, still less after. Having committed to transact in this way, that is algorithmically, deterministically, algorithmically, there's no basis for equity's intervention could be justified. And so therefore, it is our submission to Your Honor today that the test to be applied is when, plug in the laptop, so the test to be applied is when programming the algorithm, was the programmer doing so with actual or constructive knowledge of the fact that the relevant offer would only ever be accepted by a party operating under a mistake, And was the programmer acting to take advantage of such a mistake? And it is on that basis that we submit that the court below was incorrect in the test that they applied, and we ask that the appeal be allowed. Now, it would be appropriate at this point for us to apply the test and invite Your Honor to come to a conclusion based on the application of the correct test. But it's our submission that the requisite evidence to do that is not before Your Honor today. And so we'd ask that the matter be remitted to the court at first instance to determine the factual scenario around the mind of the programmer at the time, apply the correct test, and come to the requisite result. May it so please you, I have one final submission to make on risk. Right. Finally, if Your Honor were to be so minded to disagree with my prior submissions, I'd invite Your Honor to consider in the alternative the circumstances under which a contract cannot be avoided for relevant mistake. And so I'd invite Your Honor to turn to Article 37, Section 2 of the DIFC contract law at page 30 in the appellant's bundle, which reads, a party may not avoid the contract if, and that is for relevant mistake, if A, it was grossly negligent in committing the mistake, or, and especially for the purposes of my submissions to Your Honor today, the mistake relates to a matter in regard to which the risk of mistake was assumed or having regard to the circumstances should be borne by the mistaken party. And it is our submission to Your Honor today that the respondent assumed the risk, and the risk should be borne by the respondent. This is as the mistaken party chose to engage in deterministic algorithmic trading, and that is trading using software that operates on instructions given to it at the time of creation. These software do not adjust to the changes in the environment or circumstances. These software do not alert a human being to say, oh no, something is wrong here. Something is different. It is not as it is always. Maybe you should intervene. This algorithm carries out its duty, which is to buy the cryptocurrency in question at the best price. That is, whatever price is available. That is the instruction, and that is how it acts. Now, in the world of trading, glitches on exchanges are not unknown. And in the world of technology, glitches generally are foreseeable. And so having the capacity to create a program, the respondent would be aware that it is conceivable that glitches could take place, but chose to take no steps to mitigate against potential glitches. And therefore, the risk of potential glitches must be borne by the respondent. In this scenario, the mistaken party, the risk must be borne by them. And on that basis, they would be unable to avoid the contract for mistake. May it so please you, if I'm of no further help, these are my submissions. I'll cover them.
Yeah.
Well, thank you very much, James. Ahmed, do you have any questions?
Yes, I think I have an argument. Suppose I will be in the seat of the respondent, and I will say this happened out of my control and happened because of Clifty's program platform. I was not having any hand in this. Why don't sue the platform rather than coming to me?
Well, if that argument was put, I would invite the respondent to sue the platform. And my client may even be minded to join the respondent in suing the platform because, there was a glitch. But the fact of the matter is that the glitch caused by the platform, not by the appellant, the glitch caused by the platform does not arise to a mistake that avoids the contract. So there may indeed be a cause of action against the exchange, but certainly not against the appellant.
So you encourage the respondent to raise a claim against the platform rather against your representative?
Yes, those are my submissions.
Thank you.
Thank you, James. I've got a question for you, James. I was very interested in your argument on Article 37, Section 2. And I just want to look at that with you. And I just want to remind you of 3 things you said to us. You said the software on the algorithm didn't adjust to changes in the environment. You said that glitches are not unknown on software platforms. And you said that mitigate potential glitches. So I was just looking at subsection 2A. Is it also your argument that there was gross negligence here?
Well, Your Honor, it wasn't a matter that we submitted on, but it is certainly a matter that I think is worth engaging. I am aware of the test of for negligence. Was it grossly negligent? Yes, it was, and that would form a secondary or tertiary basis for the contract not to be avoided for mistake. So we are in agreement, Your Honor.
Okay, I thought you might like that one. So just help me with this then. You said that the court below applied the wrong test, and obviously what you're telling us is what the correct test is. So is it that the test below was completely wrong, or are you saying that the test was incomplete because it only looked at Article 37, subsection 1, and that there should have been some aspect of subsection needs to be applied? So what I'm asking you really is what do you say the test that should be applied is?
So we say that the test is completely wrong because the test invokes a hypothetical trader, that is a human being making the trade at the time that the decision was made. And it is our submission that because it is an algorithm, the basis upon which the decision was taken was not made when the trade was executed, but when the algorithm was created, because it is the instructions at creation that carry through to execution. There was no new thought at the time of execution. And as a matter of fact, there is no one to ask what they knew or ought to have known, because it is the computer. The only person who can speak on that matter is the creator of the program. As it pertains to section 2, that's the matter of risk, I wouldn't say that should be a part of the test, because the test is looking at the state of knowledge to determine mistake. But certainly the area of risk should have been considered at the point of first instance. And we're not imputing on your brother at the court of first instance that it was not a matter that was considered. That's not before us. That's not in the brief. But we are saying that if it were considered, it should have been found to be that the risk is assumed. And if it was not considered, then it should have been considered. And the finding would then be that the risk is assumed and there's no basis of avoiding the contract. And that is in the event, of course, that Your Honor was so minded not to agree with my initial submission, that the state of knowledge test is incorrect. May it please you.
And just help me on this test, where should the burden of proof lie? Is it for to prove that she didn't assume the risk of the mistake, or is it the other way around?
I think it would lie on the respondent in this case to demonstrate that the risk is not assumed. I think it's not that the initial position will be that you assume all risks, but if there is a risk presented, then the burden shifts to say you must then show us that you took steps, or this risk should not have been assumed, so on and so forth. And that's the structure of the test that I would suggest to Your Honor today, humbly.
Okay, well, thank you very much, James. If we could now move on to the junior respondent.
So, so Lee, just let me declare something. We are running, and the time is only 25 minutes. We have 2 submissions. So I think the participant should be noticing this, that if each can take 10 minutes, it will be fine. Otherwise, we will be out of the time.
Okay. So we'll move then to the. I should say okay. We've only got it from, and then we've got 1 rebuttal. So if we hear next from the junior respondent.
Yes.
Yeah.
Hi, am I
Oh, yeah.
audible?
I think Hudaya. It's okay, Hudaya. Go ahead.
Yes, you are. Yeah.
Okay. Good afternoon to one and all present here. May it please your honor, my name is Huda Naseem, and I appear as junior counsel representing respondent Ms. Raz Rani, alongside my learned co-counsel Ms. Janatul, who appeared as senior counsel for the respondent. Your honor, I'll be dealing with the second ground, which acknowledges the question whether the glitch in the program was an unforeseeable technical error and was it a unilateral mistake. In relation with the second ground, Your Honor, I have 3 submissions to make. If it pleases Your Honor, I'll begin with my first submission. Your Honor, Ms. Razi programmed her software to function in such a manner so as to procure a cryptocurrency called YAPL at the best price on the platform. Clevity underwent a routine upgrade, and in this statement, routine indicates that the upgrade happened on a frequent basis. However, during the routine upgrade, a glitch occurred leading to the disputed trade. It is important to bring to your honor's attention that the occurrence of the glitch was unforeseeable and not anticipated, as there was no history of such an occasion since the upgrade had since the upgrade had been done numerous times before. In line with Article 49, subsection 1, DIFC Law Number 6 of 2004, it is important to assess the intention of my respondent. It was clear while having programmed the software that Ms. Razi intended to purchase YAPL at the best possible price under standard market conditions. However, the disputed trade was not carried out under standard market conditions as the glitch was not typical. Which brings me, Your Honor, to my second submission. Assessing the factual condition of the case, one may conclude that Mr. Payne gained excessive advantage as the glitch favored the manner in which the Appellant software was programmed. Beta was programmed to sell YAPL at the best possible price. However, it was sold at a highly inflated price that accounts for unreasonableness, as it may not be sold for the same price if not for the occurrence of the glitch. Article 3.10, subsection 1, subsection A of International Institute for Unification of Private Law, the appellant had unjust advantage of the situation and took unfair advantage of the respondent's economic distress and lack of bargaining skill, as it occurred when the respondent was asleep and unaware of the unusual change. Your Honor, I would like to highlight that YAPL was sold 250 times greater than the prevailing market price, indicating that this trade constituted solely on the basis of the glitch and did not account for a commercial trade under standard market conditions. Considering Article 62, subsection 1, DIFC Law Number 6 of 2004, in the absence of any indication of the price, the parties must assign a price generally charged at the time of contract conclusion for such performance in comparable circumstances in the trade concerned, or a reasonable price if no such price is available. Lastly, My Honor, I will now move on to my third submission. In accordance with Article 82, Section 1, DIFC Law Number 6 of 2004, in the case of a simple obligation to pay, non-performance by a party is excused if the party demonstrates that non-performance was caused by an impediment beyond its control and that it could not reasonably be expected to have taken the impediment into account at the time of contract conclusion, or to have avoided or overcome it or its consequences. Likewise, the glitch caused was beyond the control of the respondent and could not foresee the same as it was not common. Further, in line with Article 37, Section 1, subsection A, it was against reasonable commercial standards of fair dealing to leave the incorrect party in error. Henceforth, the respondents were left in a position of error, and the error was so significant that a reasonable person in the same situation as the party would not have reached the same conclusion if the true state of affairs had been known. Your Honor, it is for these reasons and also those that have been given by my co-counsel that I urge you to refuse the appeal. Unless I can be of further assistance, that concludes submissions for the respondents.
Thank you very much, Huda. Ahmed, do you have any questions?
Yes, I have a generic one. I'm not going to the details. I'm asking the respondent if Mr. Rani had the chance to look at the terms and conditions of the platform. Is that was something useful for him to define his situation?
It is understood that the program was running under an algorithmic software, which indicates that it may not adapt to the circumstances of the program. However, this gave the respondent excessive advantage over the economic distress of gave the appellant excessive advantage over the economic distress of the respondent. And since the routine upgrade was done on a numerous basis, it was, however, not common for the glitch to happen.
Thank you very much. Because there is no time, we will not go more details. Eli, it's the time for the last one, I think. Judge Lee?
Hello, Your Honor. Oh.
Yes, I think now the time for the junior appellant.
Yes, I will. For the sake of time, my reply will be brief. I don't know if Your Honor, Mr. Lee is back with us.
Yeah, I'm here. Don't worry. Carry on.
Okay, very well. Thank you. My learned friend for the respondent made reference to sections of the IFC contract law, section 18 in particular, which has to do with the non-performance of a contract. It is our humble submission to Your Honors today that the contract in this sense was performed. What is of concern before Your Honor today is whether or not a party was mistaken in the performance of the contract, and it is our submission that is not the case. Further, there was reference made by my learned friend to standard market conditions, and it is our submission that the absence of standard market conditions don't give rise automatically to mistakes. Markets are dynamic in nature, and that is a part of what attracts investors to them. Further, there was my learned friend also made submissions on a reasonable price, and that a reasonable price is what should have been offered. But in market conditions, the reasonable price, when there is no other price, is the only price that is available. And so even though we say that Your Honor should not apply these section 80, if Your Honor was so minded to apply section 80, we would say that the price was indeed reasonable because there was no other price. Further, my learned friend submitted that glitches are uncommon, and it is our submission that glitches are indeed common in technology, on exchanges, stock exchanges, all electronic exchanges, cryptocurrency exchanges. Glitches are indeed common, and there was reference to leaving the party in error by my learned friend, and it's our submission that reference requires parties to be acting deliberately, and it is our submission that it was the algorithm carried out on the instructions given to it at the initial circumstance upon creation, and that the appellant did not make a decision himself to say, well, if the respondent is in an unfortunate position, I will leave them there. It was the structure of the algorithm and instructions it was given in light of the market conditions. And so I'd remind the court at this time of the correct test to be applied in our humble submission, which is that is the test, apologies. That is, when programming the algorithm, was the programmer doing so with actual or constructive knowledge of the fact that the relevant offer would only ever be accepted by a party operating under mistake? And was the programmer acting to take advantage of a mistake? And it is on this basis that we ask that the appeal be allowed and the matter be remitted to the court at first instance to make factual findings and apply the correct test. May it so please you. These are my submissions.
Well, thank you very much, James. I guess that's the end of the submission. I mean, I don't know how you dealt with things in the previous round you did. Do you want to give any feedback at this point? I know you and I need to go and have a discussion about marking and things like that, but do you want to give any sort of general feedback at this stage? All right, well, I'll just say a few things then. I think the first thing I would say is when you're in whatever kind of court you're in, obviously you want to answer it, but also try and think to yourself, if you can, is the judge trying to help me or is the judge trying to poison my case? And in fact, I think we didn't plan it this way, but I think that the questions that I was asking, I think particularly to the appellants, were actually trying to help you. And I think that, Yara, you were a bit scared of me and you weren't sure whether I was trying to help or not, so you backed away from it. Whereas James, you saw I was trying to help you and you absolutely were saying, yeah, I'll have that point as well. So always try and, obviously don't trust judges because they're horrible. And you normally find that the nicer and politer they are, the more poisonous their question. But they're trying to help me or trying to hurt me, or have they not decided? So do that. And then the other thing is, you know, don't be afraid of you know, carrying an argument through to its logical conclusion. So, you know, if for example, I think that was the point I made in relation to Yara, actually. I'm trying to think what the point was now, actually, but find me in one of the break rooms or something and I'll remember. But all I was going to say, always think, you know, if we applied this point universally, what's the position here? If we've got all these nodes all over the world, you know, maybe you say, well, look, one node just isn't enough, or whatever it might be. Janital Fudus, I think a point I was particularly thinking about in relation to you is always on your submissions, work out which ones that everyone's likely to agree with and which are the ones you really need to work hard on. So you had 3 submissions and the numbers 2 and 3 were excellent. No one could argue with those. So always focus on the one that you're going to have the most trouble with, if you see what I mean. Might, you know, make your good points first, but then leave yourself time for that. And also, always, I know it's very artificial in a moot when you sort of instructs this and my client instructs that, and it's very difficult in a moot, particularly if you're asked a difficult question by a judge, as I think you were. Obviously, in court, you will always be able to take instructions from your client, and if you need to, you say to the judge, you know, Your Honour, Your Lordship, whoever it might be, I need 5 minutes to take an instruction on that specific point, and you should never be frightened to do that. Yeah, those were the main things I was going to say on feedback, but really excellent submissions all around, everybody. Thank you very much indeed for all your hard work.
Thank you.
Thank you.
Was there anything you wanted to add on that? The feedback?
Lee, thank you very much for running this. And just I want to add something at the end of the sessions that there's always challenges between our competition between the innovation and legislation. And this is, we are seeing day to day, this is happening. However, I just want to add something like the principle of goodwill. Suppose this is also should be there, you know, And bear in mind that we are human at the end of the day. Yes, we are programming these machines, but also the goodwill principle should be in mind sometimes. Thank you for all of you. Your mic, Lee. Your mic.
Oh, sorry.
Thank you.
I was going to say, thank you very much, everyone. Ahmed, we need to speak privately, don't we? I guess is there some kind of breakout room where we do that?
Yes, I will be joining the breakout room.
Okay, if I can find it, I'll join you there.
Okay, I will leave it and I will come to that room again, okay?
Okay, great.
Thank you. Bye.
I have a question.
Thanks, everyone. Oh, yes, please do. Go on.
Do we stay back here and wait for you to come back with like we got our feedback, right? Like it's over, so we're done for the day?
Absolutely. If this is you're done. Please enjoy the rest of your Saturday. Yeah.
Thank you so much. The feedback was really
very
really
well
useful.
done, everyone. Enjoy.
Thanks
everyone.
for your time.
Okay, bye. Pleasure. Bye.